Hello and good afternoon, everyone. Welcome to the Stringer LLP webinar in what seems to be, what is gearing into our title today, kind of a never-ending series of webinars we've had over the last year and a half on COVID. Of course, we're hoping that, that there's going to be a certain point where there's going to be less of these kind of topics, but certainly COVID is still front of mind, and with the Delta variant, it doesn't seem, at least in the short run, that we're out of the woods yet, if you can forgive the expression. My partner Jeremy Schwartz and I are going to take you through some of the what we think are the key issues. Obviously, we could talk about these things all day, so we're going to try to move with alacrity, trying to cover the high points for you. Jeremy and I have been spending a tremendous amount of time drafting policies and procedures and dealing with litigation issues that have arisen from COVID-19. So I think we're just going to, the last point I guess I'll make is, I'm sure that if our experience with other webinars are any indication, there's usually quite a few questions. So if you can please submit your questions through the app in the usual manner, and Jeremy and I will do our best to answer them at the end of the session. And we can't guarantee we'll get to every one of them in lifetime, but we'll do our best as much as we can, because we often have some really interesting and thoughtful questions. First topic that we're going to look at is, let's get right to it. This is the topic of mandatory vaccinations. Can you do it or can you not? First thing, it's clear, unless you're a federally regulated employer, which some of you are, I know from looking at the list, but most employers in Ontario and nationally are regulated by the province, and there has not been any legislative move in the province of Ontario towards a so-called vaccine passport. We have seen in other provinces, namely Manitoba, Quebec, and British Columbia, amongst others, a move towards a so-called vaccine passport, which essentially is by some means, whether it's electronic or otherwise, requiring an individual to verify their status as being fully vaccinated before accessing what are deemed to be non-essential facilities, restaurants, bars, things along gyms, things along those lines. And what vaccine passports look like is a it's all over the place in terms of what provinces are doing on it. The Premier of Ontario, Doug Ford, has indicated that he doesn't want to implement a vaccine passport system in Ontario. I think so. Whether that remains to be seen, though, whether if the rest of the country picks up on vaccine passports in Ontario, which obviously is the largest province by population in Canada by some measure, doesn't pick up on it. It'll be interesting to see. The Premier, of course, is I wouldn't want to care to use the word flip-flop, but certainly has changed his mind sometimes in relatively short periods of time on COVID precautions in the past. So I wouldn't say that what we have now is necessarily the final word on that issue. Obviously, we're at a very advanced stage with the vaccine rollout. It's well underway. The province of Ontario, notwithstanding the fact that it has not required, not introduced a vaccine passport or introduced any specific guidance for employers about how to deal with mandatory vaccinations. But there is vaccination has become mandatory in certain facilities. This is a fairly recent development, and these are within public hospitals, service providers licensed under the Community Care Act, local health networks. The one that has obviously gotten a lot of attention is in the educational institutions that are requiring publicly funded schools to introduce a vaccine disclosure policy for all publicly funded school board employees, staff in private schools, and staff in licensed childcare settings. It's imposed a requirement for those staff who choose not to get vaccinated to require rapid antigen testing against COVID-19. And there's also certain requirements in the legislation around working with local public health units to increase increase education around vaccine issues. I'm going to highlight some of the other developments around vaccine policies in public and private sector. To be clear, this is not covering all of them. There's been a number of public announcements on these issues, including in the legal industry today. But for the most part, I'm just going to review some of the high-level ones. The City of Toronto on the 19th of August announced that all of its employees would be required to provide proof of vaccine status, and meaning whether they've been vaccinated. For most of you, if you are amongst the roughly 3/4 of folks in Ontario who have been vaccinated once or twice, you'll know you'll get an email receipt from the government. It says in the City of Toronto policy, any employees who have not been vaccinated or who have not disclosed their status will be required to attend mandatory education on vaccines. And then until as of September 30th, they will be required to receive the first dose on October 30th. They will be required to be fully vaccinated. The Toronto Police Service has followed up with a similar policy. And we've heard all sorts of other mandates from the Ontario Public Service to the TTC, which is the Public Transit Authority in Toronto. The Toronto Medical Officer of Health, interestingly enough, strongly recommended local employers institute a workplace vaccine policy in line with the one that I just described, issued by the City of Toronto. And there is on the city's website some details about that kind of issue. I think it's important to remember that the City of Toronto does not regulate, aside from their own employees, and most of whom are unionized. They don't regulate, they don't have jurisdiction to regulate employment law in the province of Ontario. It's a provincial matter. So that's important to remember. The federal government, obviously, we're in the middle of a federal election, but basically has said that they're going to make vaccine mandatory for all federal workers. The devil that's in the details of so many of these policies is, well, what happens if someone doesn't comply? I mean, and speaking of, and Jeremy will speak to you about the human rights side of things, but assuming for a moment that there isn't a legally justifiable excuse, which is generally a human rights grounds, medical, religious, etc., that what happens? What happens to these folks? So, I mean, bottom line, it's our view as we as these things move out. There has been a real paradigm cultural shift around mandatory vaccinations, and in my view, in terms of at least mandatory is an unfortunate word. It's a vaccine mandate, essentially saying that employees who have no lawful excuse not to be vaccinated need to be vaccinated. We've seen many high-profile, both private and public sector employers saying they're going to implement these policies largely out of thin air, quite frankly. There hasn't been any legislative change. The Occupational Health and Safety Act, the Canada Labour Code have not been amended to outside of the mandatory requirements in those sectors I talked about in Ontario for normal run-of-the-mill employers as to what they're required to do or not required to do. So, but I think the reaction is just sometimes the law moves a little more slowly than politics, and the pragmatic reality is that this pandemic has now been going on in full gear for 18 months. There is a growing sense of pandemic fatigue. A significant majority of people in Ontario and nationally have been vaccinated. So the environment and that political reality means that I think that there's a growing sense amongst the business elite and the business leaders in Canada that something has to be done to require vaccination in order to get past the pandemic. There obviously remains a very vocal group of people that are opposed to mandatory vaccinations or vaccine mandates or vaccine passports. Those issues are still alive and out there, but I think what you're going to see is somewhat of a broad consensus on this issue. Organized labor, like certainly we've talked historically, and if you tuned into our webinars before, you would have heard us talking about the old flu vaccine cases where the unions were quite, the medical unions representing the medical employees in those cases were pretty aggressively opposed to mandatory vaccination policy, but I think those are a different situation. They weren't dealing with a global pandemic, and certainly in those kind of situations, the arbitrators often said, well, like you weren't even requiring masking of guests, so it was a bit of an artificial thing to just insist on it for employees. I think that's a different world. So we don't know what a court or human rights tribunal will do, but I have a difficult time imagining, just in this context, that there's going to be widespread resistance to requiring either an employee to show proof of vaccination or alternatively be either tested routinely for COVID, and then so that's where it goes. The big kind of exception, to these to these kinds of the big exception to these kinds of issues. Is the human rights context, and we're going to discuss that in a variety of ways. So I'm just going to turn it over to Jeremy, who's going to address that issue.
Thanks, Ryan. So the human rights aspect as it applies to vaccine mandates is something that in every policy, if you're going to have really any kind of a mandatory or automatic result, there always needs to be a little bit of wiggle room built into your policy to address human rights consideration. So for example, if you have a policy which says in the case of vaccine mandates, that in order to do a particular job where the obligations of that job normally would require you to come into contact with other people and that sort of thing, if you're going to piecemeal it or if you're just going to have a carte blanche approach, you need to provide that an employee who can't vaccinate by reason of a human rights ground, which typically would either in this case be a very rare medical condition for which they either cannot be vaccinated as a result, or they're taking a medication that's contraindicated. So, for example, some people with autoimmune conditions can't take their medication and take this vaccine at the same time. And so they may be one of those very rare groups who will be exempted from a mandatory vaccination policy on human rights grounds. But other than that, there is nothing from a human rights perspective that prevents an employer from, who's again non-government employer, from imposing a requirement for employees to be vaccinated or have certain consequences apply. And so, as Ryan said, none of these policies that we're seeing have addressed expressly, at least not that we've seen yet in the news, what happens for employees who refuse. And so if an employee refuses, the question is, well, is that a job abandonment? Is that just cause for termination and they don't even get their employment standards entitlements? Or in that case, would the employee essentially be entitled to be paid a severance package, whether that be under the common law or at a minimum under the Employment Standards Act? And unfortunately, we have no case law on this whatsoever. And we'll talk a little bit later about strategies to ensure that if you have a policy and the courts confirm, which I think is the correct view, as expressed by many employee advocates, that termination for cause or job abandonment isn't actually what's happening when someone decides not to agree to go and get vaccinated absent human rights grounds. I think we're going to see a lot of employees who get awards either for ESA or for common law. And so possibly you can avoid common law. You can never avoid employment standards entitlements unless the eligibility criteria there are addressed. And we'll talk about that a little bit later. But essentially, again, there are sort of really only two issues from a human rights perspective. Unless you're a government employer, the Charter of Rights and Freedoms doesn't apply directly to the employment of your employees. Instead, it's the human rights legislation that is applicable in each province. So in Ontario, we have the Human Rights Code. In other provinces, they call it the Human Rights Act, and they have different versions of it, but it's all this legislation is very similar across the country, and it does not contain, for example, as the Charter does, Section 7, protection for life, liberty, and security of the person. And so those sorts of considerations about whether you can impose a requirement that may place someone's security or life at risk, that's not there. Instead, we deal with discrimination in employment on the basis of the prohibited grounds. And in this case, it would be religion or medical status, most likely. That would lead to an exemption to your mandatory policies or other similar considerations. When we're talking about the right to work from home on the transition back, this is an entirely new area where we're looking at family status issues, we're looking at medical status issues, we're looking at childcare and elder care issues from a totally different perspective. We have a new prism, a new lens through which we're seeing these issues. And the case law on family status prior to the pandemic essentially said that we are not required as employers to accommodate employee preferences, but the case law, which was early days, which essentially was holding that the employee first had to take steps from a practical perspective to avoid having the triggered human rights protected need in the first place. So, for example, the argument went that if you have a kid at home, that you have to look for childcare options, and only when those aren't available can you go to your employer and say, I require accommodation of my family status issue under the Human Rights Code. And what adjudicators across the country have now been saying is that turns the accommodation framework upside down, and they're not prepared to go that way. And so instead what you have is an employee who has obligations to care for a child, and there are workplace obligations that may be inconsistent with that, that triggers the duty to accommodate. that triggers the family status protection under the Human Rights Code. And then the parties engage in the accommodation inquiry, as you would for any illness. You now do it for family status. And you say, okay, what can we do cooperatively to avoid entirely this family status issue, or to address it in a practical way that permits the employee to do their job while not infringing their human right. And it's only when you reach that sort of undue hardship point, which is different for family status and disability, but essentially if the employee can't do the core functions of their job, even with reasonable accommodation of their obligations and needs to that individual, whether it be their children or whether it be an immediate family member for whom they're providing essential care, then you don't have to provide any form of accommodation in that case. It's still discriminatory, but it's now lawful to discriminate on that basis and not provide that person with active work. The question is, are they entitled to a leave of absence without pay while things, if the situation is of a definite duration, or if it's of an indefinite duration, or likely to be, excuse me, long-standing, then it's possible that at that point there's a frustration of contract and you'll have to deal with that. Never take these positions without seeking legal advice. The case law on these issues is developing, especially under the pandemic. Some of the questions that I've been getting, and frankly, my favorite is, so a lot of school boards are allowing parents to choose whether they want their kids to go in-person learning or to learn remotely. If the parents choose to have their child homeschooled through this remote learning, over Zoom or whatever the schools plan to use in their local area, is that a preference? Is that a preference from a family status perspective that now gives rise to this employer's ability to say, I don't have to support your preference to have a kid learning from home. The school board's giving you an option to send your kid in. You need to do that because we can't allow you to remote work. Or on the other hand, is that part of the employee's legal entitlement and obligation under the criminal code to provide for the necessities of life and make decisions that relate to the care of their child, to decide that they don't think it's safe for their kid to go into school. And so that means that a parent has to stay home, and that means that they must be accommodated under family status to be permitted to work from home remotely. My personal view on this, and the view that I think will win out, is that in only rare cases will that be seen as anything other than an employee preference. In most cases, if an employee has the option to send their kid in, they will be, if the employer can't reasonably be required to accommodate them by essentially making work or altering the nature of their position when everyone else is returned to let them work remotely. I think that's only going to be very rare that is something that would be required. But I will say we have no human rights decisions, no arbitral jurisprudence, no court decisions as yet dealing with this issue in the context of a pandemic on the scale that we have today. So prior to the pandemic, the law as it existed in terms of telecommuting, this is a case that came out of the Court of Appeal in 2018. Essentially, this was an employee who was with this company for 35 years. They got bought out. For more than 20 years, she had been employed on the basis of an agreement that she was recruited back after having left because she didn't like the commute, on an agreement that she had where she would come into work 2 days a week and work from home 3 days a week because she didn't want to commute into Toronto. She's 60 years old. She was there under this arrangement for 25 years. The company gets bought out. The new employer says, this isn't how we do business. And she claims that she's been constructively dismissed and resigns. The Court of Appeal confirmed that in that circumstance, this contract of employment was one which provided that she could be telecommuting for 3 days, and the employer could not unilaterally undo that arrangement, which had been longstanding and indeed contractual in nature. But the Court of Appeal confirmed that in general, the nature of the position, the nature of whether it's a telecommuting position or one which must be at the employer's discretion, one that is performed at the office, is part of that contractual framework. And so if employers have been implementing telecommuting policies on a temporary basis during the pandemic, unless that has moved into a true contractual amendment, where now this is intended to be indefinite or permanent in nature, employers have the right to require employees to come back. An employee who refuses to come back, other than for valid human rights reasons, which we discussed, or for work refusal reasons, which is something Ryan will discuss later, other than in those two circumstances, an employer likely has no obligation to permit an employee to continue working from home. They can require them to come back in and do their jobs from the office, so long as you're following the health and safety protocols as they are in place during the transition stages that we're at in your local jurisdiction. And that's that. And an employee who refuses, again, subject to human rights or the work refusal rules, that is a quit. And the thing to do is to send them a letter which says, actually, you don't have a valid human rights reason for not coming in. We're respecting all COVID protocols at the office, and your contract is for a position which is an in-office position. We're not prepared to continue telecommuting. That was temporary. And if you don't return by X date, then we'll deem you to have abandoned your employment. Now, that may trigger litigation, it may trigger demand letters, but legally speaking, in most cases, that's the correct legal answer. Now, we've been hearing a lot about these long haulers, right? So there is a growing amount of scientific evidence which makes it very clear that some people who have contracted COVID are having symptoms which are lasting for a long time. Not just that they continue to test positive for a longer period than expected, but also that they have what appears to be long-standing disablements resulting from contracting the disease. And the question is, to what extent will employers be obliged, number one, to recognize that they have disability, which requires accommodation under the human rights legislation in that province or territory, or are these simply things that we don't, as employers, have to acknowledge? Well, let's start with this. Long hauler is not a medical diagnosis, right? So the question will be, do they have symptoms of a recognized medical condition as confirmed by a medical doctor, medical professional who's capable of giving that certificate to the employer? In some cases, as you would with any other condition, you may need to seek an IME. In many cases, you may require the employee to undergo testing. In many cases, you may require a much more detailed breakdown of the employee's restrictions arising from this bona fide medical condition. So you need to treat this the same way you would with any other situation. In Honda and Keys, for those HR folks on the line who remember these cases from 20 years ago, I certainly do. This one was about 10, 12 years ago, that went up to the Supreme Court of Canada. But what happened in that case was an employee had a disablement which was validated, so it was found to be true, but their symptoms, which involved sporadically and randomly being unable to come into work due to the symptoms that arose at various times, and self-reported pain, which was not always medically verified. There were a lot of issues with validating those restrictions and dealing with that accommodation. So when we talk about long haulers, we need to imagine this as if it were any other medical condition. We need to get the medical documentation, get the information on the restrictions, and go through that accommodation inquiry. And where it's reasonable to do so, require the employee to provide updated medical information. Where there are accommodations that can address the situation, you may be required by law up to the point of undue hardship to provide those. But there is a point of undue hardship at which if an employee can't do the bona fide occupational requirements of their position, and if that's likely to be an indefinite situation, either their employment may be frustrated immediately or it may be in the foreseeable future. And these are things, again, in those complex cases, it's usually best to seek legal advice before taking steps, like deeming a worker to have abandoned their job or terminated on the basis of frustration of contract. Ryan?
Thank you, Jeremy. Interesting comments. I like Jeremy's reminder that sometimes within every word we read in the media, such as long haulers, is not necessarily a legally recognized concept. It comes down to ultimately whether or not the person's diagnosed. COVID testing, this, I mean, again, is something I think that might have been more controversial at the beginning of the pandemic than now. There's basically been two significant cases dealing with it, both of them arbitration and both of them from Ontario, one of which for sure we've spoken about on these webinars before, and that is the Progressive Care, which is a nursing long-term care facility, which had required a biweekly nasal swab and for a COVID test. I mean, this was a case from last year. Ultimately, the union asserted this was somehow a violation of the employees' privacy rights, which, I mean, as we've seen this pandemic unfold, seems frankly to be a sort of almost ludicrous position in hindsight. And basically, the arbitrator, but perhaps not ludicrous in light of earlier case law, to be fair. The arbitrator weighed the employees' privacy and health and safety goals and just said that with the protection of residents who obviously could face incredibly vulnerable to COVID-19, in this case that predated vaccines, was a perfectly appropriate step. The next case, a more recent one, this is a case of Ellis-Dawn Construction, which of course is a well-known international general contractor, builds large industrial, commercial, institutional kind of projects. And then these are the kind of projects that literally have hundreds of workers and multiple trades on them, and building things like airports and hospitals and these sort of things. And basically, the arbitrator, the union again objected to a process where the question was whether or not rapid on-site testing for COVID was a reasonable exercise of management rights. In the unionized sphere, ultimately, if the union is entitled to grieve if management exercises their rights to engage in a particular activity. The question, pursuant to the well-known legal standard of the KVP test, is whether it is in fact reasonable. I mean, the arbitrator noted there are hundreds of workers on these sites, that the workers are transitory. Construction workers move from one site to another, one region to another in many circumstances, especially if they're dealing with Ellis-Dawn, which is a presence nationally, that the risk of spread was serious. It's not merely hypothetical. There had been other outbreaks at other Ellis-Dawn sites, and that there was no evidence that other types of mitigation measures, such as masks, significantly reduced COVID-19 transmission. A key aspect of the decision, though, was the very detailed testing protocol that was like sort of the gold standard of what one could have for setting up how this testing was run. It was very sophisticated. It was very well set out. And ultimately, it was determined that it was reasonable. I think that even as time wears on, and now we're sitting in August of 2021, still, seriously discussing considerable number of COVID-19 restrictions going on into the fall, and heaven help us, the winter of 2022. We're looking at a few things. One, ultimately, the Ontario government has made it easier for workplaces to conduct what's called rapid antigen testing. The legislation that governs these kind of testing, the Laboratory and Specimen Collection Center Licensing Act, which is the first time I've ever had to say that on one of these presentations, has been amended to eliminate a bunch of sort of procedural requirements that ordinarily are required for these kind of tests. Remembering that that antigen testing is a screening tool, but it is useful potentially for monitoring asymptomatic folks that may be symptomatic. And we know that people that transmit COVID, it's become pretty crystal clear, don't necessarily have to be symptomatic to do so, which is one of the aspects of the coronavirus that makes it such a dangerous and widespread issue because of that unfortunate reality. The reality is, I mean, if you're going to be administering, you want to certainly, I think, take a look at and get some legal advice on how to set up a testing program that complies with government guidance, that deals with any kind of privacy and human rights issues. These are things that you can get specific advice on how to structure that to your workplace. My reaction to the situation is, though, that I think that any type of resistance to COVID testing for people that aren't vaccinated is going to be something that's going to probably not get a lot of legal sympathy. It's apropos to my earlier comments about sort of the political reality of this, is that at some point, I think the law is always about balancing competing interests. And I think that the privacy interest versus the safety interest, safety is going to trump here. And I think some of the reasoning that, was pretty crystal clear in caressive care, where the stakes were very high, could even be continued to be applied, because you don't know, even though it's the group of employees may not be as vulnerable as the most vulnerable folks, patients in long-term or people in long-term care homes. Individuals can be, compromised and have all kinds of vulnerabilities, comorbidities of COVID are quite widespread in the population of all ages, including obesity and other such things. So it is important to understand from my perspective that I think it's not a matter of if you're developing a testing protocol for those who aren't vaccinated, it's a matter of how you do it. From my perspective, and I think that the legal challenge on that is going to be in the details, not in the specific issue of whether you can test or not. A lot of our clients have been asking us about work refusals. How has that been playing out? Notice there's been some media coverage, more specifically in the Toronto Star, who has accessed government statistics to get a sense as to where we're at with work refusals related to COVID. Remember that work refusals have a very specific process in Ontario. That first, one has to try to deal with it internally at stage 1, and if you can't, then the work refusal moves on, where a decision is made by the Ministry of Labour as to whether or not the work refusal is valid or not. In work refusals, ultimately, work refusals, which is very old legislation, was historically meant to deal with physical conditions in workplaces, whether a machine is safe, whether a particular kind of personal protective equipment is necessary or not, whether modifications need to be made. But the reality is, certainly, because the way the legislation is written sort of contemplates the workers in the facility. They go to a specific place, and there's detailed protocols of what happens during the work refusal and such. I wasn't really as much contemplating someone phoning in saying, I'm scared to come to work because of a pandemic. It obviously wasn't written with that in mind. But what I can tell you is that out of the 482 work refusals, only 8 of them were allowed. So, that is obviously an incredibly small number. Virtually all of them, including all of them in the education sector, interestingly enough. And you may have read our article earlier, where certainly the unions tried to bring a whole case to the Labour Board dealing with multiple schools and multiple school boards. Basically, all of them in the Labour Board said, well, no, you got to do it individually at every school, at every specific work location. And so the union argued in that case that would make it very difficult, if not impossible, to enforce the work refusal provisions, and perhaps they may have been prescient on that point. But the bottom line is, work refusals haven't been going anywhere in terms of dealing with COVID. I'm not entirely really surprised at it, provided that an employer is following the very well-known, well-documented ad nauseum public health guidelines around social distancing, around masking, or encouraging those who can work from home to do so, all those things. And it's difficult to foresee, other than shutting the facility down, that there's not going to be a lot of minutiae. You're either complying with these measures or you're not. There may be the odd workplace that has specific things like ventilation in schools and such. But certainly it appears the ministry has been reluctant to use the work refusal power to get intimately involved in the 500 or so disputes that made it as far as stage 2 at the Ministry of Labour, which is a relatively small number in light of the size of the size of the Ontario economy. What does it mean? I think it's just for those of you a stay tuned type of thing. It's my view that this particular statistic will probably mean a call from workers' advocates, trade unions, and the like to beef up the work refusal provisions, either to make them force the ministry to be more aggressive about them, and perhaps allow such things as multiple workplaces to be adjudicated in a single hearing. I think certainly that, which would be very cumbersome and unfortunate from an employer's perspective, but I think you're going to hear certainly some calls for amendments to the Act around this, because I think there's going to be a point of view, perhaps not a fair one, that the work refusal provisions have not been particularly helpful to the employers. Moving on to the next slide. So this is now the issue of constructive dismissal, and we'll turn it over to Jeremy.
Thanks, Ryan. So yeah, we're covering off an awful lot of topics that span the entire horizon here. So we're going to change gears a little bit and talk about some of the contractual issues that have arisen. And in general, constructive dismissal, reduced hours claims have been on the rise, whether they be in actual claims to ministries of labor, whether they be in actual claims of constructive dismissal commenced in civil court, or whether they simply be demand letters, or maybe another way to put it is accusing letters, which our office has been dealing with daily from employees, lawyers, and paralegals asserting that protocols or changes or whatever have violated someone's privacy rights or have violated their entitlements or breached their contracts, and maybe a constructive dismissal demanding that things be put back to the way that they were before they were this way or that. And ultimately, these issues all come down to fundamentally, what is the contract? What does it say? Who has the right to do something, and where there's an absence of express language in a contract dealing with a particular issue, does the employer have a sort of innate right to do something, or do they not have that right because it's not expressed or implied in the words of the contract? And so a constructive dismissal from the fundamental contractual standpoint occurs when an employer makes a fundamental unilateral change, so one that's not condoned or consented to by the employee, to those core terms and conditions of employment. And so it can't be something minor. It can't be, even in some cases, a 1% wage drop is probably not going to do it. We're talking about something more substantial. 10% wage drop or loss in compensation, I should say, is generally held to be enough. Sometimes it can be less. There were a few cases I've read where 3 or even 4% were sufficient in terms of a reduction on someone's pay, so that in their circumstances that was deemed to be a constructive dismissal. But generally speaking, 10% is sort of a rule of thumb, if for lack of a better way of putting it. Employees who are constructively dismissed have an obligation to mitigate by looking for work. The question is, when they claim that the change is objected to, but before they say that they're quitting because the employer is not reversing its decision, assuming they go that far, are they required to continue working even under those conditions with the new changes imposed by the employer in mitigation of their damages claim? And so in many cases, a constructive dismissal claim where there are changes to hours of work, where there are changes to procedures, where the types of things someone is doing in their job have materially altered because the nature of the position has changed. These may be constructive dismissals, but in the context of a pandemic where these changes were made in good faith and for bona fide operational reasons, and these are things the employee can absolutely do, especially if you're not reducing their compensation, in many cases they may have to either continue doing that work and it's not a constructive dismissal, and the employer will change it back when and if it can, or they can say they've been constructively dismissed, but then they may be required to continue working under these amended terms and conditions to mitigate their loss. And essentially, they may have zero loss if there was no change in their compensation. They just have a change in duties or hours. The reasonable period during which an employee can continue under these altered terms without saying, I object, I've been constructively dismissed, even if they don't quit and stop working, before they're deemed to have condoned and essentially tacitly accepted the employer's right to make these changes. That varies in the circumstances, but employees have to object within a reasonable period of time. Even if they keep working under protest, they have to say, I'm not okay with this change, I'm just working because I need a job. And if they don't, if they wait too long before they make that assertion, they may lose the right to claim constructive dismissal. Now, layoff, and this is an important issue, employers may not have the right to lay people off. And there's an assumption, for example, among many employers, or at least there was before we all started writing about this issue during the pandemic, more so than before, is that an hourly employee is somehow different than a salaried employee, or employees in certain industries are automatically subject to an implied ability by employers to implement layoffs. These assumptions are just that. They are not applicable in every case. They're dangerous to rely rely on when we're talking about potentially a significant obligation to pay out entitlements on a termination, which is triggered by a layoff that an employer didn't have the right to implement in the first place. And what would have happened at the beginning of this pandemic, for those of you who have been joining us for 18 months in these sessions, is that the Ontario government and governments around the country implemented different changes to employment standards legislation so that even layoffs which were permissible under employment statutes wouldn't trigger terminations of employment if they're implemented as a result of the COVID-19 pandemic. In Ontario, what happened was the employer community got a last-minute reprieve of the infectious disease emergency leave, which provided that anyone who was put out on a layoff as a result of COVID, starting in on March 1 and any time thereafter, would be deemed not to have been laid off under the Employment Standards Act, but instead to be on infectious disease emergency leave, the IDEL, and that this leave was an unpaid leave. There was no obligation to continue benefits during IDEL unless you had a contractual obligation to do so during a leave of absence, which you've contracted for separately. And the expiry date of IDEL leaves has been continuously, sort of the can's been kicked down the road. Presently, unless it's extended again, Saturday, September 25th is the last day. And so as of September 26th, of 2021, any employee who's out on an IDEL because they were put on a layoff, if you can't return them because you have no work for them, now they are essentially back on that layoff. It's not retroactively deemed to be a leave beyond September the 26th. So starting September 26th, the clock starts running. They are now considered to be on a layoff. And the question again will be, do you have the right to put them on a layoff in the first place? And so any employee who was upset about the fact that they were put off on this IDEL or layoff during that period would have had an obligation to come forward and complain about it. I'm going to talk you through a few cases in a second where that is exactly what happened, and we're dealing with what the courts will say about that. But for employees who waited 18 months to complain that they were put on IDEL and to claim that it's a constructive dismissal and never really said mum about this, I think that they may run up against that reasonable limit of time during which an employee has to come forward and say, you've unilaterally altered the terms and conditions of my employment by implementing a layoff. You didn't have the right to do that, but I'm not going to quit because I need a job. If they didn't say that, or at least in some way object, then very likely by now they'll be deemed to have condoned that change. But arguably, that may not be the case. And we don't have any court decisions on this yet, and even the courts can't figure out, and we'll talk in a moment about the conflicting jurisprudence on this issue, whether IDEL modified the common law as it relates to constructive dismissal when an employer issues a layoff. One minor variation in Ontario is that a few months back, the government implemented an obligation to provide 3 days of paid sick leave to employees who are off because of COVID. So if someone's off on IDEL, then they're off because of COVID. Regardless whether they have COVID or not. If you don't have a policy which provides people for paid sick days or paid leave in that circumstance, then you're now required by law to pay them the 3 days. And provided you qualify, you can go to the Workers' Compensation Board, the WSIB, and you can seek reimbursement for that pay. But that is a different system for that. But in general, it's otherwise unpaid and benefits don't have to be continued. Fast forward in April of this year, we had the case in Catino, and essentially what happened here is the court said, yeah, we read the IDEL provisions, but they don't expressly say that they alter the common law. The statute expressly says that unless the statute says otherwise, it doesn't apply to civil remedies or civil rights that an employee has outside of the statute. And so as a result, the court in that case said that nothing in the introduction of the IDEL took away an employee's right to sue for constructive dismissal or gave an employer the right to implement a layoff, which is converted to IDEL. And so as a result, some employees and a lot of employers became very nervous that what this case heralded was the beginning of really a swell of cases and demands where employees all over the place were claiming that you didn't have the right to put me on a layoff in the first place. I don't have a statutory only termination clause in my contract, so I'm entitled to common law reasonable notice. And so as a result, pay up, essentially. We got a number of demand letters where people were saying that. Thankfully, we got the case in Taylor. So Taylor came out and the Superior Court looked at Catino and expressly said, that's just wrong. Clearly, IDEL was implemented for a specific purpose. It was done for policy reasons. We need to respect the legislature's policy decision here, which is that employers shouldn't be penalized for putting people out on a leave that they're statutorily required in many cases to impose, or that through other COVID-related economic symptoms, let's say, they were unable to continue to employ that person during that period. That's not really a termination. That's at the fault of the employer. That's what IDEL was put in place to prevent, was this groundswell of constructive dismissal litigation. So we're going to respect those provisions. And then even though Taylor had come out, the Superior Court, same level of court in a case called Fogelman, came out within a couple of weeks of that, didn't know about Taylor. So these two judges didn't read each other's decisions or talk about this. They came out, both of them read Catino. Taylor said Catino is wrong. Fogelman not only followed Catino, but it held that by refusing the employee's request for their employment standards entitlements when they claimed constructive dismissal, that employer was therefore liable for punitive damages, and they awarded something like $20,000 or $25,000 in punitive damages against the employer for implementing an IDEL, which was statutorily permitted and deemed that employee to be on a IDEL, statutory protected leave, not a layoff, and yet that wasn't enough. They were entitled to common law reasonable notice and punitive damages even for the employment standards side, which is an interesting twist because technically they may not be entitled to their entitlements under the Employment Standards Act and termination and severance at all if under the ESA they're covered under a statutory leave of absence. Sort of an irony there that I'm sure the employer didn't expect or appreciate. So what do? We have one case going one way, one case going the other way. Unfortunately, what we've got here is a situation where the courts have not agreed. The legislature has not stood up and made it clear. They could have done. It takes a quick stroke of a pen to make this clear that you can't be constructively dismissed if you're legitimately on an IDEL, as in a leave that is a result of COVID-19 related issues. And so, unfortunately, in this circumstance, we'll provide a few practical options, but this risk now remains. So, one very important aspect of IDEL and any other kind of leave that you have under the statute is that employees who are off on a statutorily protected leave therefore have a protected job. That's what it means to be on a statutory protected leave. They have the right to reinstatement to their position, or if it doesn't still exist, to a suitable sort of alternate position if their old job no longer exists, legitimately doesn't exist. Now, that doesn't mean that if you took their job, let's say there were 5 components mainly to their job, and you gave it to 4 other people so that they wouldn't have a job anymore, that job may still exist. And the cases prior to the pandemic made it very clear that as long as the duties are still out there, an employer may have an obligation to reinstate that person to that job by cobbling back together these various duties. So I think that as we transition past that September 25th end date, which is the current date, we're going to see a lot of employees say, well, 3 of my colleagues are still there, where's my job? Right? And a lot of employers will have their feet put to the fire on whether or not that job still exists, whether they were able to bring the employee back sooner, whether they were still off as a result of COVID. So it's not enough simply to be off. You have to still be off as a result of COVID. If at some point 2 months ago you could have brought people back, but you chose not to, then there may be an issue about whether you have violated employees' rights under the statutory leave provisions. Now, keep in mind that the law has not changed on the employer's ability to manage the business in a bona fide, good faith manner. And that means that employees who are off on a leave can't expect conditions to be frozen, can't expect when the leave is over that the world will be the same as it was. And especially following a pandemic, I don't think any employee can reasonably expect that the employer won't have made any changes whatsoever to the way that it operates. Of course, that might have an impact on how many people are required, what jobs are available, what divisions get wound down, and so forth. The slightly more complex issue is how do you weigh the individual employees against the other? And so these rights under the Employment Standards Act are not group rights, they're individual employee rights. Each employee who's off on a leave has the right to reinstatement, and they have a right to an individualized assessment as to whether their job still exists. So if you have 5 people who are doing a similar job and you only think you have room for 4, you're going to have to justify why you chose John as the odd man out. And if you don't have a pretty good reason for it, then you may get an allegation that this was a reprisal. And then you'll have to prove that there were bona fide business-only reasons why you selected one employee over another. Outside the unionized sector, you don't necessarily need to give any credence to seniority unless you have an agreement or a policy that says you'll do so. But in general, if you choose the oldest, most disabled employee with the most seniority to say that you don't have a job for them, but you do have a job for the 4 people in their 30s who are of good health, I think you might have some explaining to do. So you're going to need to take a clean eye and have clean hands when you do this assessment and go through that process. So how do we avoid these claims? Keep employees updated throughout the process. You want to lay off to the expiry without agreement. So if someone's been off, don't terminate their employment before September the 25th, unless you really have no choice or it's absolutely clear and your crystal ball works better than mine does and you know their job is done. So an example of that would be you've closed the actual building, there's no job to come back to. That would be a good example of certainty, where you don't have to leave them out there accruing service and increasing their severance entitlement. You can just, cut ties at that point. Bring people back when you're able to. This isn't an opportunity to bring back your favorites. This is an opportunity to not be obliged to actively employ people when you don't have work for them to do. But when you do, you can't say with a straight face anymore. You can't argue that they're off because of COVID-19. They're off because of your preference. And if an employee can prove that, that's a violation of the employment standard protections to their job protection in the circumstances. Don't treat this as a chance to cull the herd. Again, you can't just take the bottom 5% of your productivity driven folks and say, we just don't have work for you anymore, and give it to all the folks you like the best. Be very careful when you do this, but I've been helping a lot of employers ask for severance volunteers. And so again, it needs to be voluntary, but what you can absolutely say to anyone you want is, look, you're out on this leave. We hope to be able to return you when the time is up, but we don't know. Reading the tea leaves, we don't believe there's going to be a job for you when your leave comes to an end. And so we'd like to offer you the ability to basically waive off on your reinstatement rights in exchange for a package. And then you both have certainty, but you want to make clear in that offer that if they choose not to accept the voluntary exit package, that you will respect their rights under the statute and return them if the job becomes available again. You want to secure agreements for partial or modified returns if they're on a temporary basis. So if you need to make modifications, if you need people's hours to be different, if the work that you have that is available on a temporary basis is a little bit different, you want to make it very clear that anything that's different, anything that's new is on a temporary basis, if it truly is, as a result of the COVID-19 situation, and that you'll reassess regularly or when the situation returns to normal, if ever. And you want to keep records and reasons. And as any good employment lawyer will tell you, don't put anything in writing that you wouldn't want a judge or the Ministry of Labor to see. So you don't want to be sending those emails where you say, we don't want John to come back. The guy's just too old. We may as well bring back the other 4. You don't want that in an email that has to be produced when John inevitably brings a reprisal complaint because you don't bring him back to work. So now I'm going to turn this over to Ryan to talk a little bit about what happens if you go the wrong way on this advice.
All right. Thanks, Jeremy. So we're moving into the employment law area in terms of what does COVID mean for notice periods, which means we're talking about non-union employees here, people that are terminated without cause, and historically, all of you who deal with the situations will know that the amount of notice an employee is entitled to is based upon the length of service they have with the employer, their age, to a much lesser extent than it used to be, character of employment in terms of whether it's managerial or not in nature, and it's more about how easy it is to replace that employment in terms of in terms of mitigation. And the bottom line reality is that, and it's historically been the case, that notice periods are arranged. And there have been a lot of cases where people with similar position, similar age, similar wage getting different notice periods from courts. There's sort of an element of risk to that. But certainly as soon as the pandemic came out, plaintiffs' lawyers have been taking the position that COVID may provide an increase in notice in some cases, where it can be shown that it has an ability to find replacement employment. I mean, frankly, I've always personally, and it's poetic if I may, taken some issue with this as being a part of the analysis of how much one's notice is. If one can't find another job, I would have thought that would have had more impact on the obligation to mitigate. And maybe certainly there isn't as much of an expectation to mitigate in the context of where it's COVID and there's no jobs type of thing, if that's indeed the case, remembering that COVID has not affected every industry equally. It's absolutely devastated such things as the restaurant industry, but things like manufacturing in many instances has gone on as it always has. Ultimately, so what does this mean though? That's my opinion, but the law seems to be somewhat all over the place as to whether or not there is the existence of this so-called COVID bump, remembering that a lot of that is, most wrongful dismissal cases are settled. So certainly the COVID bump has certainly been to an extent a level of posturing and invention of plaintiffs' lawyers, but there has been some judicial support for it. The first case I wanted to quickly talk about is this is the Yee versus the Hudson's Bay Company. Basically, the court is just the only reason I'm mentioning it is the court quite helpfully is saying, look, if the termination took place before COVID, then its impact on, so basically if it took place, the termination took place before March 2020 when the COVID-19 epidemic became a widely known quantity, that it's not appropriate to provide a COVID bump. And I mean, I think that's a perfectly logical decision. It seems absurd that that would be that the employer's actions would be judged against the standard to which they were objectively not aware, remembering that the scope of this pandemic caught the world flat-footed, let alone average employer. But there's been a couple of cases I think it's worth talking about. And again, much like Jeremy was alluding to, we have some different approaches. First, this is the case of Iriotakis v. Peninsula Employment Limited Services. The plaintiff was a business development manager who had been with the defendant for just under 2.5 years. So we're looking at relatively short service employee terminated 1 week after the state of emergency. The plaintiff was awarded 3 months pay in lieu of notice. The court acknowledged that the pandemic had some influence on the plaintiff's job search. The court stated that the impact of the pandemic on the job market was highly speculative and was uncertain, both as to degree and to duration. Of course, we know now that the duration has gone on for some time. At the time the plaintiff's employment was terminated. The court also warned about the dangers of applying hindsight when calculating the appropriate period of reasonable notice. Now, this is our kind of judge from an employment management side employment lawyer's kind of perspective that ultimately, I mean, historically, certainly, I mean, there's no symmetry in this, right? Like an employer can't say that the notice period should be lower because we're in dire financial straits. Courts don't allow that as an excuse, and the law is clear on that. But so in my view, it's equally inappropriate to then start looking at market conditions to assess what an employee's notice is. But of course, I'm a management side labor lawyer, so I have employment lawyers, so I have a different perspective, perhaps. The next case, this is Kraft versus Firepower Financial Inc. This was a Ontario Superior Court of Justice decision, again, factually similar in the sense that the employee was terminated in the second week of March. Remembering that it takes a while for these cases to come to hearing, and that's part of the problems. The courts are absolutely backlogged on these cases. This is an employee that was $70,000 a year, 5.5 years of service, so longer service than the previous employee. And what I think was interesting is that the court awarded a COVID bump to this employee. As I indicated, the judge says there's evidence the pandemic impacted on the plaintiff's ability to secure new employment. In light of that evidence, he deserves at least somewhat of a figure above the notice period. And he said, I will add a month, which, in the context of a fairly generous notice period already for a 5.5-year employee by giving them 9 months. And that's the absolute high end of the range, in my view, for an employee of that level of service. So the court added another month. We already had a court that had been fairly generous to this employee already, and then added. So what does it mean? Ultimately, it certainly doesn't weigh well for employers. Like, remember the court in the court in the Peninsula case was talking about speculation about the job impact and such. So I think it's fair to say that there is going to be a risk, particularly in industries that have been hard hit by COVID. Notice is always a fact-driven analysis. If someone was a bartender or a restaurant manager pursuing a lawsuit, which neither of these two entities were, one can expect that the court would be fairly sympathetic to an argument like that. Whereas if you were a worker in a manufacturing plant in an industry that was unaffected by COVID, it would be difficult to surmise. It would be less easy to justify. And also, I think the point which is very interesting, what Kraft shows us, is we're talking about a 1 month bump from 9 to 10. I mean, certainly we're not seeing the jackpot. Remembering that that notice period that employee had was already just based upon their service. It would have been, at least in that judge's view, awarded in any event. And as I said, it's at the higher end of the range of what I would anticipate a court would award in those circumstances. So what do we mean with COVID bumps? I think you can't assume it's certainly not going to be less, and in some cases it could be more. We're really waiting for the other shoe to drop to see if there's going to be a court that's either going to categorically say, look, this is a notice analysis, and this issue speaks to mitigation, and we're not going to start speculating on that issue, or are we going to see a court that's going to say, look, this industry has been devastated, we're going to give significantly more that an employee is entitled to. And there's a certain element, if you terminate an employee in these circumstances, you've got to face the risk that there is at least a possibility that a judge is going to be prepared to raise the notice period, and possibly more than was done in the Kraft case. So I'm going to turn it back over to Jeremy just to get it to our sort of comments on the various government relief plans that are.
Thanks, Ryan. So I'm going to give some practical tips in a moment of how employers can respond to some of these contractual issues we've been discussing. But Ryan and I presented on this in March of last year when the pandemic was sort of, when people just started to hear that the pandemic was coming, we prepared a pandemic planning webinar. And these slides, although they've changed a little bit, I continue to flog this dead horse. It's a terrible expression. In any event, there is a program that many employers are familiar with, some may be aware of but have never looked into, called Supplementary Unemployment Benefit Plans. This is a program provided under the Employment Insurance Act, where an employer can put in place a program whereby they top employees up when they're off on a whether it be a layoff or a leave of absence due to quarantine or COVID related reasons. An employer can put in place a plan which is self-funded by the employer, either through a trust fund or directly from its general account. And the employee gets up to 95% topped up. So if EI is paying them 55%, the employer can add another 40 up to a certain limit within the plan. It's a plan that has to be filed with the folks at Service Canada. They have dedicated customer service, and maybe that's the wrong word, dedicated agents who are there to assist. In my experience with employers who've been trying to implement these programs, those agents have been very helpful, and you're usually assigned a specific case worker who can help work with you to ensure that you get this done right. And a side of these plans is that if it's not something you had in your contracts before, whether as a unionized employer and you're negotiating this into your collective agreement, or whether it's for non-union employees in their individual contracts of employment, this is a form of new consideration. And so if you're looking for changes to employment contracts, whether that be the ability to lay off in the first place so that you can avoid the sort of Catino, Taylor, and Fogelman debate altogether, you want to have contracts that say you can lay off to the limits of the employment standards in your jurisdiction, you can do that. And employees don't get access to the sub plan unless they sign off on the new agreement with that new term. The sub plans that I've assisted employers to prepare, we put a schedule to the back of the plan itself. The plan is one page, the appendix is another. The plan says that the group of employees who are covered are the ones who sign off on the schedule, and only those who sign the schedule will then be eligible under the sub plan in the event they want the top up. And so this is an elegant way of killing two birds with sort of that one stone. At least that's my take on it. Also, don't forget about work share agreements. So these still are available for up to 76 weeks. There is discussion about whether any of these agreements need to be extended, given that the pandemic has gone on for 18 months. And so my belief is there may be some wiggle room on the period between when one plan ends and how long you have to wait before another one can, if they don't extend. And so the specifics of that, again, you can work with your agent who's assigned from Service Canada. And again, these folks are very knowledgeable, and they in my experience have really gone above and beyond helping employers ensure that their work share agreements are implemented properly, administered properly, and that the workers get the benefits and the employer gets the benefit of this arrangement. And so a work share agreement, for those who aren't aware, is where two or more employees are essentially sharing the available work. And the way that's achieved is everybody agrees to reduce their work by the same percentage. And so that percentage reduction usually, though it's not required by law, usually translates to a pro rata reduction in their compensation. If they're salary, then it's a pro rata reduction that way. If it's hourly, you're just paying them for fewer hours, and it's achieved that way. The benefit of these agreements as well is it's a three-party agreement. The employee can't be put on a work share agreement if they don't agree to it. And so as a result, an employee can't agree to work share and then say that they've been constructively dismissed, because it's not a unilateral alteration by the employer of terms and conditions of employment. This was done with their informed and written consent. So a few practical thoughts, as I said, on the contractual issues, and then we're going to get to the many questions that have been coming in during the course of the presentation. And of course, we'll try to get to as many as we can. If you haven't yet and you have a burning question that you'd like us to try to address, please do use the platform to enter your question. If you can't see the question panel, hit the orange arrow and then click on the buttons and follow through to submit a question. For those of you who have been asking whether the slides and a recording will be available, they always are available. Shortly after this presentation, we're going to send out a survey asking for your feedback, which we use to develop and improve our program. So we ask that you do take a few minutes, usually takes 2 minutes to respond to the 5 or 6 questions we ask. And when you do that, you'll be directed to a landing page, which gives you the link on our site where you can download the slides. And in terms of the Media Center, link for the recording of the program, that usually takes a week or two before we get that up and running. We have to do a few things, but once that's done, then you will be able to watch this program again, or send a link to that to your colleagues if you think they would benefit from a watch. So again, sort of some concluding practical thoughts. First of all, take this opportunity. Introduce new and better contractual terms. This isn't just self-serving coming from a lawyer who helps employers draft and review employment agreements. What the cases that have come out from, we haven't talked about it today, but Waxdale and a whole number of other cases over the last 2 or 3 years, and especially during the pandemic, have shown is that a lot of employers' policies and contracts are full of holes, or there are aspects which are non-compliant and create not only enforceability issues, but potentially risk and exposure to significant liability. So now is the time. If you want to impose testing and vaccination requirements in a contract, you just need to provide consideration in exchange for that. So if an employee wants a raise that they're not otherwise entitled to, they have to sign a contract that says that they will provide proof of vaccination subject to the human rights, any human rights reason why they can't be fully vaccinated, with any vaccine that has been approved by Canada, by the Canadian medical or Ontario provincial health authorities for use. Bit of an issue there on what is emergency authorization and what is full authorization. Of course, the FDA in the US just approved the Pfizer vaccine for folks over 18 and over. for regular use, not just emergency authorization. One hopes that that'll happen in Canada without too much delay after that. But these are things you can put into a contract. And once they're in the contract and the employee has signed it and it's enforceable because it's written in an enforceable manner, it pays heed to the human rights limitations of how far reaching that can be, and you provided fresh consideration in exchange, now you can fire for cause. Now you can, and now the firing for cause, and maybe I should mention this after Waxdale, very clearly, an employee whose contract says you have to be vaccinated or you have to submit to regular COVID testing or else you've reached a material condition of your employment, that's not the same thing as an intentional misconduct, which is not condoned by the employer within the meaning of the Employment Standards Act. And so time will tell, but my personal view is that the courts and labor board will likely say that you can have a contractual term that's enforceable like this, which deprives an employee of their common law entitlements if they don't vaccinate or they don't submit to testing. But I do believe they will probably be entitled to their employment standards entitlement, whether that be to notice or severance and vacation pay following a termination for violation of those new contractual terms. There's an argument otherwise, but I think the stronger argument will be that it's not intentional misconduct in the same way that the Employment Standards Act has been interpreted to date. Update your contracts and policies. Let's include new provisions that allow you to implement layoffs, where you don't have to worry again about Fogelman and Taylor and who wins the day. Train. When you're bringing people back, you have all these new policies, you've made all these updates and upgrades and changes. Now's the time to train people and or refresh them on your human rights and health and safety policies. Check that box. That's a reasonable precaution. These are things that you may be called upon in the future to prove that employees who haven't been there for 2 years are aware of your expectations. You want to ensure management toes the company line. I can't tell you the number of clients who've contacted me and they've got managers or frontline supervisors who are vocally anti-vax or anti-mask even, and they're happy to say these things to the employees. If as a company you are not on the same page as those sentiments, then you need to make it express in a memo or an email in writing to those people who represent the company as supervisors, as managers, as directors, as officers, that the company's position on these is A, B, and C, and that they are being directed on pain of discipline up to and including termination of employment if necessary for some of these frontline folks who just can't get it through their heads that the world has shifted, that they need to toe that company line on these issues. And finally, of course, keep calm and carry on. We'll all get through this. And now Ryan and I will take some time to go through those questions. So we do have an awful lot here. So I'm just going to pull them up, and then I will sort of moderate this between Ryan and I. You can just bear with me, folks, for a second. I have to expand the window. Okay. Okay, so Ryan, someone has asked that we discuss sort of a hybrid approach where you incur, as opposed to mandating vaccination, where in industries and sectors where it's not required by law, as you said, for like federally regulated enterprises, where we would be encouraging vaccination and using masking and other sort of protocols for those who don't vaccinate. Can you give us any thoughts about the sort of carrot and stick approach that this person's asking about?
Yeah, and that's a very good point. Certainly, leaving aside where there is a specific legal obligation, and we briefly touched on some of those obligations in the federal sector and in certain sectors in the provincially regulated economy, in which case if there's a law that says you have to have such a mandate, thou shalt have that mandate. But otherwise, there's certainly nothing wrong with dealing with that, engaging it that way, particularly in lower risk settings, if that's the direction that you want to head, certainly, but you're going to, and at that point, certainly I've heard the theory said by some commentators that this is a less confrontational, or some would say respectful way of dealing with the issue, in terms of like there's the practical reality that if people are being required to test all the time and wear a mask, which is, you know, unpleasant at the best of times, that perhaps this is just a way of getting it done. And as long as that, I mean, if that's considered to be, you know, that could be a perfectly appropriate alternative. I mean, putting on my sort of where the law is going on this, where I think kind of guidance is going on this, I think eventually I think it's going to be more of a justification for a somewhat more coercive approach, particularly if the fourth wave becomes more severe. But as the law stands, absent a specific legal requirement, that is a legally compliant approach in most cases.
Thanks, Ryan. That's interesting. Yeah, we've had a number of clients who came to us and asked us to develop mandatory vaccination policies, but first they asked us on the, you know, what's the law on all this? And when they learned that you can't necessarily automatically terminate someone who doesn't go out and vaccinate and you know, further to your policy, and they may have to pay out, you know, severance packages to those people who decline to vaccinate. Very quickly, we start getting questions about the carrot and stick approach. So I'm glad we had that question, and thank you, Ryan, for those comments. One question that sort of strides the two of us here, so maybe I'll handle it since it's more on the human rights aspect of it. If someone is claiming an exemption from vaccination on medical grounds, can an employer ask for a doctor's note? So the answer to that is yes. And so you have to be careful whenever you're asking for a medical note, because you're not asking for a medical note because someone is off on a COVID leave, for which under the Employment Standards Act, you may not be allowed to ask for a medical note. What you're doing is you're asking for medical validation that the employee has a valid human rights reason for not vaccinating in accordance with your policy. And so first step is your policy reasonable and enforceable? And does it take into account human rights issues? Second, was it enforced, implemented properly, whether you're unionized or not? But finally, what do you do once you get that information? Now you have personal medical health information, and you have to be the custodian of that information. You have to keep it safe. You have to only share that information with the smallest number of people who need to know. And you have to be very careful not to make it obvious to everybody around that individual whether or not they are vaccinated or not, because that is, again, that would be disclosure of their personal health information. So the short answer is yes. The long answer is, you know, you need to do so correctly. And finally, what happens if they refuse? So if someone is saying that they have a valid medical reason, aka a human rights reason, not to follow your policy, they have to show you that that's true. And you have the right to require them to provide that proof. And if they don't provide you with proof, then you don't have to accept that they have a valid human rights reason for not following your policy. And so that's the consequence, right? So the human rights code doesn't allow people to simply force everyone else to take them at their word. They have to establish through reasonable evidence that they have a human rights basis for a policy or procedure or measure not applying to them, or when they're seeking accommodation. And if they don't provide that evidence, then they can be treated like anyone else who doesn't have a valid medical reason for declining to follow your policy. So Ryan, we've got another question here. Knowing that the vaccine isn't 100% effective, that's some standard, would it not be wiser for employers to implement regular testing instead of vaccination requirements? Well, what are your thoughts on that? I know I have my own.
Yeah, I have my own too, and I'm going to put this with a caveat. I'm not a doctor. I'm not an expert in medical testing. I'm not a virologist. So I'm coming at this through obviously being an occupational health and safety lawyer from a legal lens. And I think that what the evidence would show, in my view, based upon extensive reading on the subject and looking at it from a legal lens, is that the evidence would probably show that vaccines, that the idea that vaccines aren't 100% effective is probably not going to be something a court or the labor board would find to be persuasive, that masking and other measures asking other measures were more effective. Some could say if you wanted to have overkill, could you do both? But the mere fact that vaccines aren't 100% effective is not, in my view, evidentially something that a court would be satisfied with, at least in my view, without speaking. But that's what I think a court would do with it, leaving aside, unfortunately, there's a political dynamic to this. So I make no comment on the legal side of it, on the political side of it. Just simply, that's what I think a court would say based on the evidence as I understand it.
Yeah, I would agree with you on that, Ryan. And I guess the fact, a lot of people will raise the idea that vaccines may not be 100% effective, but what you need to keep in mind also is that employers that want to avoid liability, which won't be captured under workers' compensation. So if third parties, not employees of other covered organizations, for example, contract COVID as a result of an outbreak in your facility, if customers come into your facility and can show that they contracted COVID because you haven't taken reasonable precautions to prevent infection and spread, that may be deemed to be grossly negligent. And so the question is, in Ontario, for example, and in other provinces, there's legislation which says that a company cannot be held liable for the spread or contraction by other folks of COVID-19 unless they were grossly negligent. And there's a lot of issues about that in long-term care right now, raised by families who are concerned and are arguing that that standard is unfair, or in the alternative, that the homes met that threshold of being grossly negligent. But I think that a very persuasive argument can be made that an employer that imposes that obligation to have everyone vaccinate who doesn't have a good reason not to is not being grossly negligent. I think that that's pretty good evidence that you're taking reasonable precautions to protect not only yourself, but also people in the community who may be exposed to your workers in your workplace. So I think there's a pretty strong argument against the suggestion by that question. Ryan, here's another question that maybe will be good for you. Is it reasonable for workplaces to screen visitors and guests for their vaccination status? If the step to mandate for employees is made, so we impose mandatory vaccination protocol for employees, it would track that we consider this for anyone visiting as well.
Yeah, Jeremy, that gets into some pretty complicated stuff, right? Because it really depends on what you're dealing with. I mean, ultimately, I can certainly appreciate the argument. People saying, well, you're going to insist the employees do it, but we have, we're a shopping mall and thousands of people coming in, and how do we handle that? I think that the answer is it's going to depend on the circumstances. The answer is it's also going to depend upon, what happens with the provincial law around vaccine passports. Certainly, there's nothing in my view at this point that would necessarily stop a business from prohibiting people from prohibiting from, say, screening guests for COVID or asking for proof of vaccination. The one thing I will say, and there's a fly in this ointment though, in terms of the medical exemption, certainly we have seen in the bylaws and the local public health units around masking, it is illegal in most of them to ask for someone for proof of their medical requirement in terms of a human rights ground. So,
a ridiculous loophole, I think we all agree, but it's there, yeah.
Yeah, it's there. It's a little, it's ultimately, I think the intention is noble in the sense of privacy, but it certainly hamstrings an employer that someone's, or almost every one of these public establishments is an employer by definition, that, we can't ask, someone says, well, I have a medical exemption, but prove it. It kind of, makes that a bit of a challenging thing. So I think the practical answer is that something you'd want to get advice on how to handle it specifically in your circumstances. But bear in mind, I think stay tuned. I think once, if and when the province implements a vaccine mandate, your vaccine passport program of some kind, you can, reading the tea leaves, I suspect the Premier will reverse himself on that, but I could be wrong. That's when it will become a little more clear in what direction this heads.
So here's one that's directed at me. So I mentioned during my presentation that if an employee chooses virtual classes for their child, presumably a child who's young enough that they can't be left home alone, that this would be a preference and not necessarily trigger family status accommodation. What evidence of documentation can an employer ask for? So again, this goes back to the same comment where an employee is asserting that they can't vaccinate because of medical reasons. Anyone who is asserting that they have a family status or any other human rights ground that would prohibit the application of a policy or rule to them because of their particular circumstances has an obligation to provide evidence reasonable in the circumstances that that actually is a ground that applies, that the protection and prohibition applies in the circumstances. And so realistically, what evidence you can require will depend on what objection the employee raises. And so in my view, it's going to be very hard and very limited circumstances in which an employee is going to be able to say, if we treat this as a preference, right, that it's not a preference. They're going to have to say, my child is high risk. We have at home someone who has a comorbidity or who has a immune deficiency, and so if my child who's underage to be vaccinated goes to a school, they're more likely to bring it home, and even though my child won't get sick, they are more likely to kill my husband who is immunocompromised, for example. That would be an example of a situation where it's not a preference, where they're doing it because it's essential to keep the folks at their house safe. Whereas for most people, if it's just a general fear of COVID, I have to say, I find it very difficult to believe that absent a valid medical objection by that employee or a true family status issue like that comorbidity issue or immunocompromised issue with other folks in the home, that this would be treated as anything other than a preference. So in terms of what you can ask for, well, if they give you a reason, you can ask for any evidence that shows what that reason is, but I would only ask for evidence if that reason will satisfy you in the first place. If whatever they tell you is their reason for not doing it wouldn't suffice regardless, then you don't need any evidence because you're not going to apply that exemption. So someone asked, and I guess this is probably because of something I said, but it relates to Ryan's topic. But since I just spoke, maybe Ryan should touch on this. What do you mean when you say you need to implement a vaccination policy properly? So maybe you can make some comments, Ryan, on how to properly implement a policy like this.
Well, I mean, when we say properly, we're speaking with what legal requirements are and aren't. And that speaks to how, first of all, obviously recognizing the human rights typical exemptions that will apply, which in most cases are going to be disability, creed, and one could possibly say gender, because potentially pregnancy. And there's certainly been many of my clients have had some comments about some vaccine hesitancy among women of fertility age because of concerns about the potentially legitimate concerns about the unknown impact of vaccines on fertility. So you want to make sure that it addresses those issues appropriately. And also you want to make sure that it has what the alternatives are if the person is not getting vaccinated for unprotected reasons, whether that means you're implementing a masking and social distancing requirement, or what the consequences are. And so and also how it's if one heads more in the disciplinary direction. I mean, certainly you want to give people a reasonable opportunity who aren't vaccinated to get vaccinated. So like the City of Toronto policy that I mentioned, where there's this dates where you have to have your first one, this is when your second one, and what the consequences are. Those are all the things that are about dealing with it properly and phrasing it appropriately. Because I mean, it's obviously could be something that's going to be the subject of some kind of litigation, whether it's ultimately human rights or employment related on wrongful dismissal or a grievance. Those are the and certainly ultimately. Obviously, if you're dealing in a unionized environment, you're going to want to have the policy written in such a way that would survive the scrutiny of an arbitrator as a reasonable exercise of management rights.
Thanks, Ryan. So I'll take this next question because we have one more after this, and I like the one, I think that one's better for you. So I'll take this one, even though it's a little bit more on your end. So a question about whether it could be a constructive dismissal to require by policy, presumably, an employee to agree to vaccinate or test, go through, rapid tests like once a month, once a week, or whatever it is. And my sense on this is that a constructive dismissal only occurs when an employer is making a unilateral and fundamental alteration the terms and conditions of employment. The question whether an employer has an implicit right and indeed obligation under health and safety law to take all precautions reasonable in the circumstances to protect its workers, I think would argue in favor of a form of protocol, maybe up to and including a mandatory vaccinate policy, and that would not be a constructive dismissal to implement such a policy. And so if you were to implement a policy where employees, similar to the City of Toronto mandate that's come out for certain covered industries that Ryan mentioned, where employees either have to vaccinate or they have to submit to regular testing, as I see it, that's not a constructive dismissal. That's an implied obligation of employees to comply with a policy that is probably not only within the employer's rights to impose, but indeed failing to apply some form of policy. Not necessarily a mandatory vaccination policy, but a policy which takes reasonable steps to avoid the transmission and infection of people in the workplace and in the community, I think may expose the employer to damages and to claims not only from employees, but from third parties. So I think it's not a constructive dismissal risk so much as it's a bulwark against other forms of claims against the employer. So now we have 1.5 minutes for Ryan to answer the last question in our little box here, which is, if you have a policy that requires the non-vaccinated folks to take a rapid test before they start, can you require them to show up early, unpaid, take that test, and not get access to your building or site for 15 minutes prior to the start of their working day?
You know, there are sometimes that I can get on sort of an emotional, sort of gut level situation as to why some employers might find that to be incredible, that someone who for non-protected reason chooses not to be vaccinated, then you have to pay them for the testing process. But there are some things that, you know what, don't make a mountain out of a molehill, my father was fond of saying, and I think this is one of those situations. Not paying people for doing things associated with their job is the road to class action lawsuits in some cases. You know, at the end of the day, it's potentially a violation of the wage and hour sections of the Employment Standards Act or the Canada Labor Code, as the case may be, and it's just not worth it. I think that could you try to make that argument? Could you put that in there? Sure. Could that cause you a whole lot more legal problems than that particular issue is worth? I think so, on any number of fronts. So it seems to me that the employee requiring someone to show up early and not be paid for it is just not worth the wage and hour violation issues in and of itself. Whether it's a constructive dismissal is another question. My view is not to do it. It's not worth it.
Yeah, Ryan and I are on the same page on this. I mean, maybe the thing to do is, unless you've got a factory line that has to start up at exactly 8 a.m., then you just let that person have their test and they walk into the building 15 minutes later. Another side issue that comes out of this one is, can you make employees pay for these tests? And that's another issue entirely. And I've got some employers who have asked us to provide policies which say that absent a government program which pays for the test for the employer, which does apply in some industries and sectors, that employees who decline to vaccinate will not only be required to take these tests regularly, but will have to pay at cost. Typically, it's about $40 per test for these tests and the results. So that's a nice little slap on the wrist for employees who refuse to vaccinate without medical excuse. And with that, those are our, now someone's going to ask whether that's a constructive dismissal. I think that's unlikely, but you know, who knows? We'll wait for the next decision from Taylor when that employee brings the next case. So thank you again, everyone, for your fantastic questions, for your patience, and for joining us once again for this program. Again, shortly you will be receiving an email seeking your feedback. It comes from SurveyMonkey. So I don't know if your email spam folders don't notice that. I know some people have said they don't get the survey. It comes through SurveyMonkey. We don't send it direct from our emails. And once you send that, you'll get a link to the slides. And again, the program will be up on our media center within the next week. So thanks again, and stay safe, everybody.